What if the system designed to help troubled children actually destroyed them? Colorado mothers are now exposing something disturbing. State-run juvenile detention centers that allegedly held children in solitary confinement for weeks, denied them mental health treatment, and sent them back into the world more damaged than before. Now these families have filed a federal civil rights lawsuit claiming the state violated their children's constitutional rights. Welcome to Court Decoded. Today we examine a devastating civil rights case that reveals what happens behind the locked doors of juvenile detention and the mothers fighting to expose the truth. They came forward one by one, Colorado mothers with different backgrounds but the same devastating story. Their children had been sent to state juvenile detention facilities, places designed to rehabilitate troubled youth and set them on a better path. But what these mothers describe is something far darker. According to their accounts, children as young as 13 were held in conditions that no parent could have imagined. Kids entered the system with behavioral problems and emerged with severe trauma, psychiatric disorders, and emotional damage that would haunt them for years. These mothers recall the phone calls, voices of their children begging for help, describing isolation cells and unanswered cries for mental health support. For some families, detention transformed minor offenders into deeply traumatized individuals requiring years of therapy. Now, these mothers have done something remarkable. They've joined forces to file a civil rights lawsuit against the state of Colorado, demanding accountability for what they say amounts to unconstitutional treatment of the most vulnerable citizens. Colorado's juvenile detention system houses hundreds of young offenders at any given time. These facilities are meant to provide structure, education, and rehabilitation for youth who have run afoul of the law, many of them arrested for nonviolent offenses, truancy, or minor drug charges. But according to court filings, the reality inside these facilities tells a different story. The lawsuit describes a system plagued by chronic understaffing, where overwhelmed guards resort to isolation rather than intervention. Children reportedly spend 22 to 23 hours per day locked in small cells with minimal human contact, a practice that child psychologists have long condemned as psychological torture for developing minds. Educational programs allegedly exist only on paper. Mental health services promised to families at intake are described as sporadic at best, non-existent at worst. For children who entered with depression, anxiety, or trauma histories, the environment allegedly amplified their conditions rather than treating them. The facilities themselves, some dating back decades, reportedly suffer from deteriorating infrastructure and safety concerns. At the heart of this lawsuit lies one of the most controversial practices in juvenile justice: solitary confinement for minors. The mothers allege that their children were routinely placed in isolation cells for extended periods, sometimes weeks at a time. International human rights organizations have classified prolonged solitary confinement of juveniles as cruel and inhumane treatment. The developing adolescent brain is particularly vulnerable to the effects of isolation. Research consistently shows that even brief periods of solitary can trigger anxiety, depression, hallucinations, and increased risk of self-harm in young people. Yet according to the lawsuit, Colorado facilities used isolation not as a last resort, but as a routine management tool. Children placed in these cells allegedly had limited access to education, exercise, and family contact. Some reportedly lost track of time entirely. Mental health professionals have documented that the trauma from such experiences can persist long after release, creating lasting psychological scars. The lawsuit argues this practice alone constitutes cruel and unusual punishment, a violation of the Eighth Amendment rights that every American, regardless of age, is entitled to. The civil rights lawsuit filed by these Colorado mothers invokes some of the most fundamental protections guaranteed by the United States Constitution. The legal claims are significant and far-reaching. First, the plaintiffs allege violations of the Eighth Amendment, which prohibits cruel and unusual punishment. The use of prolonged solitary confinement on minors, they argue, crosses the threshold into unconstitutional cruelty. Second, the lawsuit claims violations of the 14th Amendment, which guarantees due process and equal protection under the law. Children in state custody have a constitutional right to reasonable safety and basic necessities, including adequate mental health care. The lawsuit alleges the state systematically failed this obligation. Additionally, the mothers argue their children were denied access to education, a right protected under Colorado state law for all youth, including those in detention. The legal theory is clear. When the state takes custody of a child, it assumes responsibility for that child's well-being. The state becomes, in legal terms, the guardian. And these mothers argue Colorado failed catastrophically in its guardian role. The lawsuit was filed in federal court, a strategic choice that grants access to civil rights statutes with teeth. At the core of the legal action is Section 1983 of Title 42 of the United States Code, a powerful tool that allows citizens to sue state actors who violate constitutional rights. This statute has been used in landmark civil rights cases for decades. The mothers are represented by civil rights attorneys who specialize in challenging institutional conditions. Their legal strategy focuses not only on individual harm, but on systemic failures, arguing that the problems within Colorado juvenile detention are not isolated incidents, but rather predictable results of deliberate policy choices and willful neglect. The lawsuit seeks multiple forms of relief: monetary damages for the harm inflicted on specific children, injunctive relief that would force the state to reform its practices, and perhaps, most importantly, declaratory judgment, an official court ruling that the state's conduct has been unconstitutional. Such a ruling would set precedent and create pressure for lasting change throughout the juvenile justice system. The state of Colorado, faced with these serious allegations, has mounted its defense. Government attorneys argue that juvenile detention facilities operate within constitutional bounds and that staff members work diligently under difficult circumstances. The defense contends that the children placed in these facilities often arrive with significant behavioral challenges, prior trauma, and mental health conditions that predate their incarceration. Managing such populations, they argue, requires measures that may seem harsh but are necessary for maintaining safety, both for staff and for other detained youth. State officials have pointed to recent reform efforts, suggesting that problems identified in the lawsuit reflect past practices now being addressed. They argue the court should consider ongoing improvements rather than freezing judgment based on historical conditions. Additionally, the defense raises the doctrine of qualified immunity, a legal shield that protects government officials from civil liability unless they violated clearly established constitutional rights. This doctrine has become increasingly controversial in civil rights litigation, often serving as a significant barrier for plaintiffs seeking accountability. Colorado is not alone in facing scrutiny over juvenile detention conditions. Across the United States, a growing movement demands fundamental reform of how society treats children who break the law. Research has consistently shown that punitive detention models fail to reduce recidivism. In fact, youth who experience harsh detention conditions are more likely to reoffend than those who receive community-based interventions. States like California, New York, and Missouri have implemented alternative approaches that prioritize rehabilitation over punishment, with documented success. The Colorado lawsuit arrives at a critical moment in this national conversation. Juvenile justice advocates view cases like this as opportunities to establish legal precedent that could reshape standards across the country. If the mothers prevail, their victory could provide a template for similar lawsuits in other states. The implications extend beyond courtroom walls. Legislative bodies increasingly pay attention to judicial findings when crafting policy reforms. A ruling against Colorado could accelerate nationwide efforts to end practices like juvenile solitary confinement and mandate meaningful mental health services for detained youth. Behind every legal argument and court filing are real children whose futures hang in the balance. The mothers who brought this lawsuit speak of sons and daughters who entered detention with problems that seemed manageable and emerged as fundamentally different people. Some of these young people now struggle with severe PTSD, their trauma responses triggered by enclosed spaces, authority figures, or even the sound of heavy doors closing. Others face ongoing psychiatric treatment for conditions that allegedly developed or worsened during their time in state custody. Educational setbacks compound the damage. Children who missed months of meaningful schooling while detained find themselves years behind their peers, limiting their opportunities for higher education and employment. The lawsuit seeks to quantify these harms, to place a dollar figure on destroyed potential and stolen childhood. But as the mothers who filed this case readily acknowledge, no amount of money can truly compensate for what their children lost. What they seek most of all is change, a transformed system that will not inflict the same damage on future generations of Colorado's troubled youth. As of now, this civil rights lawsuit continues to work its way through the federal court system. No final verdict has been rendered, but the case has already achieved something significant. It has forced a public conversation about what happens inside Colorado's juvenile detention facilities. The mothers who brought this lawsuit have transformed personal anguish into collective action. Whether they ultimately prevail in court, their courage in speaking out has illuminated conditions that the state might have preferred to keep hidden. The legal lesson here is profound. Children in state custody do not forfeit their constitutional rights. The Eighth Amendment's prohibition on cruel and unusual punishment applies to juveniles. The 14th Amendment's guarantee of due process means that detained children are entitled to basic safety and adequate care. When the government fails these obligations, the courthouse doors remain open, even for the most powerless members of society, and for the mothers who refuse to stay silent. If you found this case fascinating, hit subscribe and the notification bell for more legal breakdowns. Drop your thoughts in the comments. Should states face harsher accountability for juvenile detention conditions?